Maintaining peace and security and resolving disputes in peaceful means is the main purpose of United Nations stated in the Article 1.1 UN Charter. Article 1.1 of UN Charter states that it is the purpose of UN to bring about the peaceful means and its conformity with the principle of justice and international law, adjustment of settlement of international disputes or situation which might lead to a breach of the peace. Article 2.3, which lists the main principles of international law, states that all members shall settle their international disputes by peaceful means in such manner that international peace and security and justice are not endangered. While in Article 33, we can read that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or the other peaceful means of their own choice. The Security Council shall also, when it deems necessary, call upon the parties to settle their disputes by such means. As mentioned in the Article 33, the catalogue is not a comprehensive one, and states can decide to resolve their disputes in any other peaceful way of their choice. What is an international dispute? Permanent court declared that the international dispute is a disagreement over a point of law or fact, a conflict of legal views or of interest between two persons. Before we start analyzing the peaceful means of resolving dispute, we have to discuss few general rules. So in today's lecture, we will discuss few main peaceful means of resolving disputes. But before we start analyzing the peaceful means of resolving disputes, we have to discuss few general rules. First of all, states are not obliged to resolve their differences at all. And this applies in the case of serious legal conflict as well as political disagreements. All the methods which are there are applicable only upon the consent of the particular state. States also have a free choice as to mechanism adopted for settling their disputes. And it has to be noted that the parties to a dispute have the duty to continue to seek a settlement by other peaceful means agreed by them in the event of the failure of one particular method. Basically, the techniques of peaceful means of resolving disputes are two types: diplomatic procedures and adjudication. Diplomatic procedures, it's resolving disputes by the parties themselves or with the assistance or other entities like states or international organization. Adjudication procedures involve the determination by a disinterested third party of the legal and factual issues involved either by arbitration or by the decision of judicial organs. First of all, we will discuss negotiation. Because of the most of the international disputes are resolved by negotiation. This is usually diplomatic and face-to-face agreement, and the agreement achieved by negotiation will be legally binding if this is what the parties intend. Negotiation does not involve any third party, so that's the difference between negotiation and other forms of dispute management. In certain circumstances, there might exist a duty to enter into negotiation. Article 283.1 of the Convention of the Law of the Sea states that when disputes arise between states and the dispute is about the interpretation or application of the convention, the parties to the dispute shall proceed expeditiously to an exchange of views regarding its settlement by negotiation or other peaceful means. Mediation and good offices involve a third party or third parties. Good offices is a technique of peaceful settlement of international disputes in which a third party, acting with the consent of the disputing states, third party serve as a friendly intermediary in an effort to persuade them to negotiate between themselves without necessarily offering the disputing states substantive suggestion towards achieving a settlement. One of the examples of the good offices method is the role played by, for example, US President in 1906 in concluding the Russian-Japanese War, or the function performed by USSR in assisting in the peaceful settlement of the India-Pakistan dispute in 1965. Another might be the part played by France in encouraging US-North Vietnamese negotiation to begin in Paris in 1917. Currently, the role of UN Secretary General as an important peacemaking actor has evolved through extensive practice. The range of activities carried by the Secretary General has included also good offices, but as well as mediation, the dialogue process, and even arbitration. Very often negotiations cannot be conducted because there is no consensus regarding the facts which arose around two parties and which started the dispute. A commission of inquiry is another method of settling international dispute, and is usually a preliminary means by which facts might be impartially found in order to provide the basis for a resolution of the dispute. Its purpose is to produce an impartial finding of disputed facts and thus to prepare the way for settlement of dispute by other peaceful methods. The parties are not obliged to accept the finding of inquiry. Right now, we will discuss International Court of Justice. The International Court of Justice is the main judicial organ of the UN and was the successor to the Permanent Court of International Justice, which was established after the First World War in 1921. What is very important to say that only states can be parties in case before the court. This is very important to mention because I have noticed that quite often there is many confusion with this whole international courts and tribunals. We have International Criminal Court, which is also based in The Hague. We have Permanent Court of Arbitration, which is based even in the same building as International Court of Justice. We had the Tribunal for Yugoslavia also in The Hague. We had the Tribunal for Lebanon right next to The Hague in Leidschendam. We have also International Courts of Human Rights, which is again being quite often confused as a part of EU system, but it was International Court of Human Rights was set up by the Council of Europe, and Court of Justice is working in the framework of the European Union. Now we have now Pakistan has the case in International Court of Justice, the Jadhav case. And I think most of us at this moment are familiar with what International Court of Justice is doing. And we understand that it has nothing to do with the individuals, that it's between India and Pakistan. Of course, it's related to the individual, in this case, Indian national, but he's not the party in this case. India filed an application claiming that Pakistan violated the Vienna Convention on Consular Relations in 1963. When we think about the International Court of Justice statute, the most known or well-known article. It's the Article 38. Article 38 describes the sources of international law. Article 38 states that the court whose function is to decide in accordance with international law such disputes as are submitted to it shall apply. A. International convention, whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom as evidence of general practice accepted as law. C. The general principles of law recognized by civilized nation. D. Subject to the provision of Article 59, judicial decision and the teaching of the most highly qualified publicists of the various nations as subsidiary means for the determination of rule of law. Point 2. This provision shall not prejudice the power of the court to decide a case ex equo et bono if the parties agree thereto. Decisions are binding on state members. If any party to a case fails to perform the obligation which are coming out from the court verdict, the other party might have recourse to the Security Council, which may, if it's necessary, make recommendation or decide upon measures to be taken to give effect to the judgment. Judges are elected regardless of their nationality. Of course, they need to fulfill the basic requirements as high moral character, qualification, competence in international law. The International Court of Justice has 15 members. They are elected for 9 years with possibility of re-election. No member can exercise any political or administrative function or engage in any other occupation of a professional nature. No member of the court might act as an agent, counsel, or advocate in any case. No member might participate in the decision of any case in which he has previously taken part as an agent, counsel, or advocate for one of the parties, or as a member of a national, international court, or of a commission of inquiry, or in any other capacity. No member of the court can be dismissed unless in the anonymous opinion of the other members, he has ceased to fulfill the required condition. Of course, to provide the impartiality of the judges, judges can enjoy diplomatic privileges and immunities when engaged on the business of the court. Every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially. The general rule is that the General Assembly and Security Council elect members from the list of persons nominated by national group in a permanent court of arbitration. The Secretary General preparing the list of the nominated person and submitting it to General Assembly and Security Council. Candidates must obtain an absolute majority of votes in both the Assembly, General Assembly, and the Security Council. All questions shall be decided by majority of the judges present. If the judgment does not represent in whole or in part the anonymous opinion of the judges, any judge shall be entitled to deliver a separate opinion, which is votum separatum. The judgment is final and without appeal, but with the possibility of revision. In the event of dispute as to the meaning or scope of the judgment, the court should prepare this explanation upon the request of any party. One of the most important issue while discussing the International Court of Justice is the jurisdiction of the court. The jurisdiction of the court is founded upon the consent of the parties. The consent has to be voluntary and indisputable. Court cannot therefore decide upon legal rights of third states which are not parties to the proceeding. As in the case of arbitration, parties might refer a dispute to the International Court of Justice by a special agreement or compromise, which will specify the terms of dispute and the framework within which the court has to operate. So that's the first possibility. Court might also be granted jurisdiction over dispute arising from international treaties, where such treaties contain this so-called compromissory clause. Quite a big number of international treaties, both bilateral and multilateral, do include a clause warning the International Court of Justice jurisdiction with respect to questions that might arise from the interpretation and application of these conventions. For example, 1948 Genocide Convention, of 1965 Convention on Investment Disputes, 1965 International Convention on the Elimination of All Forms of Racial Discrimination, also includes this compromissory clause. So with the optional clause declaration, the International Court of Justice statute states that the states parties to the present statute may at any time declare that they recognize as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation, the jurisdiction of the court in all legal dispute concerning the interpretation of the treaty, any question of international law, existence of any fact which is, if established, would constitute a breach of international obligation, the nature of extent of the reparation to be made for the breach of international obligation. International Court of Justice can also issue an advisory opinion. Advisory opinion is legal advice provided to the UN or any specialized agency by the International Court of Justice in accordance with the Article 96 of the UN Charter, which states that the General Assembly or the Security Council might request the International Court of Justice to give an advisory opinion on any legal question. Other organs of the United Nations and specialized agencies, which might at any time to be so authorized by the General Assembly, might also request advisory opinion of the court on legal question arising with the scope of their activities. So today we very briefly discuss a few peaceful means of resolving dispute. We discuss negotiation, we discuss good offices, commission of inquiry, and also the role of International Court of Justice in settling international disputes.